first-degree murder case, and the district attorney is going to ask for the death penalty if the person is convicted. The district attorney is going to want to ask a lot of questions on voir dire about individual potential members of the jury and their feelings on the death penalty. So if you have people who say, I don't care if this guy is convicted of boiling his 2-month-old baby in a pot of water until the skin came off of it and then peeled it and hung the skeleton up. I don't care what you prove, in other words, that this person did. I am not going to vote to put him to death because I have religious beliefs, my own personal philosophy tells me taking a life is wrong, and I'm not going to participate in that. So I'm telling you that up front. If that person sticks with that story and the lawyer or the judge can't sort of detach them from that certainty, then that person is not going to be serving on the jury. The district attorney will say at some point, let's say that's juror number 5, Judge, the state will thank but dismiss juror number 5. Like, I don't want her on my jury. So each side gets a certain number of challenges where they can say, I talked to these folks, for one reason or another, I don't want this one on my jury. So peremptory challenges are challenges for any old reason at all. And each side gets a limited number of peremptory. It depends usually, if it's a 12-person jury and it's a civil case, usually each side gets 6 people that they can strike for no reason or any reason. Challenges for cause are the kind of thing I just told you about. My religion tells me that I can never vote to do it. No matter what you prove he did, I'm not voting to put him to death. So that would be a challenge for cause because the juror has already told you I'm biased against the death penalty and I'm not changing my mind. So challenges for cause for those kinds of reasons are unlimited in number. Okay? They just don't come up that often. Peremptory challenges are like little bits of gold for both sides during the jury process because what it means is, yeah, I don't really like that lady sitting on the back row or on the far left. She's like giving me really dirty looks and like she just has had it with me and I haven't even started yet, right? So I'm getting a bad feeling about her. I think I'm gonna thank but excuse juror number 2. Why? I don't have to give a reason. I'm using up one of my 6 peremptory challenges. I don't have to state why yet.
Who decides whether it's peremptory or for cause? The judge?
Yeah, the judge. But the lawyers know too. I mean, for cause means I don't care what you prove, I'm never going to vote for you. You know, that kind of thing. It's got to be something very dramatic. Most of them are peremptory.
And the lawyers can argue.
Yeah, the lawyers can argue. Yeah. So usually the lawyers have been given a list of these potential members of the jury, and they're given a little bit of information about them. You usually have the person's name, obviously, you have their address. Sometimes, they tell you where they work. In federal court, you get a little more information about prospective jurors than you do in state court. So you want to ask questions depending on what kind of case you have. If I'm the plaintiff and it's a sexual harassment case, the defendant is going to get up and ask any of you, ladies and gentlemen, ever been a party in a sexual harassment claim? Have you ever sued anybody for sex harassment? Have you ever been sued by anybody for sexual harassment? The defendant, who's going to try to defend and prove that his client didn't sexually harass my client, he doesn't want anybody sitting on that jury that says, yeah, I've sued my former employer for sex harassment. The defense lawyer goes, okay, we thank but excuse juror number 6. Get her out of here, right? A woman scorned is going to deep six the case. She's going to go for the plaintiff. I don't want to get rid of her. No. I'm sorry. Yes, it would be. I'm sorry. Yes, it would in fact be a peremptory. it's not really for cause, cause I don't get to ask her that. If I asked her, well, just because you've been a plaintiff in a sexual harassment case before, does that necessarily predispose you to going along with the plaintiff? Or can you listen to the evidence and judge the case purely on the evidence? Well, most people, unless they want to get out of jury duty, say, I can judge it on the evidence. And if they don't say that, the judge will step in and go, okay, ma'am, so are you telling me that you are not willing to wait and hear the evidence in this case to make a decision? Are you saying that, like, it doesn't matter what the plaintiff proves or doesn't prove, you're gonna vote for the plaintiff? And the person will almost always go, no, Judge, that's not what I'm saying. You know, I might be a little biased in her favor because I had a similar experience, but I can judge the case on the evidence. Once you say that, you're in, unless the other side wants to get rid of you. So when all of that is done, we hopefully get a 12-person jury, if it's gonna be a 12-person jury, and usually they pick one or two alternates, in case somebody gets sick, so the whole case doesn't go down the toilet and you have to start over again. You get rid of the sick one and you slip in one of the alternates. So the alternates have to be there every day, hearing all the same evidence that the regular members of the jury do. So, when that is done, the jurors are sworn in. They raise their hands, they take an oath to judge the case purely on the evidence, and we roll. So, the first thing that happens after the jury is selected is what we call opening statements. Here, other than in voir dire, in a trial, in the state court, the opening statement given by each lawyer, or the lawyer for each side, one lawyer for each side, is the only time, other than the closing argument, which comes at the end of the trial, that the lawyers actually get to speak directly to the jury, except for also voir dire if the lawyers have done the questioning. Lawyers are not permitted to speak to the jury because, as the judge will instruct the jury from the get-go, lawyers are not they can't testify. Nothing that comes out of a lawyer's mouth is evidence. And all you people on the jury need to be concerned with is evidence. Evidence is documents, and it's testimony that comes out of the mouths of witnesses who are sworn to tell the truth. Notice, none of these lawyers have been asked to take an oath to tell the truth. So when lawyers are talking, it's argument. They're trying to make you see the case the way they want you to see it, based on the evidence. But it ain't evidence. So they will address the jury directly in opening statement and in closing arguments, and then that's it. But you don't have to listen or believe anything any of the lawyers say. They don't usually go quite that far, but close. So what you do in an opening statement is you get up and the lawyer is going to give the jury a preview of his or her side of the case. So if I'm the plaintiff, I'm going to get up and I'm going to tell the jury a little bit about my client. I'm going to try to do everything I can to personalize my client. I'm not going to call her my client. I'm going to call her Susie, right? I'm going to try to personalize her, make her a real person to the jury. And I'm going to tell the jury what evidence we're going to put on. I'm going to say, here's the story. This is what happened to my client. And in the course of the trial, you're going to hear from, 3 different witnesses. I give them the names and I tell them what those witnesses are going to testify to and how their testimony is going to support my client's side of the case. When I'm done, when the plaintiff's done, sit down, shut up, defense lawyer gets up, and the defense lawyer says, okay, well that was all very interesting, but as you know, there are 2 sides to every story, and there are 2 sides to this story. So let me tell you what you're going to hear from the defense side of the case. Blah, 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 blah. So you don't want to, opening statements are kind of a balancing act, because the lawyer doesn't want to overpromise the jury. You don't want to tell them, like, you're going to have more evidence than you can, evidence going to be up to here. You're not going to be able to breathe. You're going to be smothered in evidence. You don't want to tell the jury that they're going see things and hear from witnesses if that's not really going to happen. Because anything you promise the jury and you don't deliver on, they're gonna remember that and hold it against, usually, your client. So you can't overpromise, but you also can't be afraid to let the jury see that you, the lawyer, really believe in the case. So you gotta walk kind of that fine line. One of the other parts of an oath that members of a jury take is to say, again, as I mentioned, that they will in fact judge the case based on the evidence. Which means you shouldn't have your mind made up till you've heard all of the evidence, right? You've heard from all the witnesses, you've seen all the documents. Except that polls for all eternity are often taken, generalized polls across the country, and those polls are usually very similar in their results. And those results often are that the jury, most of the members of the jury will admit that they probably had their minds made up by the end of the opening statements. Okay? They would never admit that in a case because they'd be thrown off the jury. That meant they didn't listen to the evidence. They only heard what the lawyers said and decided which side they were probably going to go for. But that is an exceedingly important bit of information for lawyers to have, because you know that a lot is riding on the opening statement. So you better put some serious time in on preparing it, and you need to be as convincing as you can, again, without overpromising. So once both sides have given their opening statement, the judge will say, "Plaintiff, call your first witness." So remember, if you're the plaintiff in the case, the plaintiff has the burden of proof. What is the burden of proof in a civil case? This was on your quiz. Anybody remember?
Preponderance.
By a preponderance of the evidence. Okay? So the majority of the evidence has to go in favor of the plaintiff for the plaintiff to meet her burden of proof and therefore win the case. So plaintiff goes first. And what is it in a criminal case? They got to prove the case by what? Beyond a reasonable doubt. Excellent. Okay, so what the plaintiff is going to do first with his or her first witness is conduct what we call direct examination of that witness or the plaintiff's lawyers. Direct examination is the kind of questioning that the lawyer does to a friendly witness. So I'm calling the plaintiff's best friend at work that I already know, of course, what she's going to say. Defense lawyer probably does too, because he probably took her deposition, right? I know that she's going to support my client's side of the case. So I call her, therefore she is a friendly witness. And the kinds of questions I ask her are dictated by the fact that she's a friendly witness. So I can only ask her non-leading questions on direct examination. On cross-examination, when I'm finished questioning this witness for my side of the case, the lawyer for the defendant gets up and conducts on that same witness cross-examination. Cross meaning she's a witness for the plaintiff, it's the defendant's lawyer questioning her, right? They're on opposite sides of the case. So the law presumes that since the person is on the opposite side of the case, they are not a friendly witness, but in fact a hostile witness, who probably is not going to cooperate with the lawyer for the other side of the case. Not going to make it easy on that lawyer. Therefore, on cross-examination, because the witness is considered to be hostile to the lawyer for the other side who is cross-examining her, leading questions are permitted really just to move the process along. Does anybody know, can anybody give me an example of a leading question?
Did you kill him?
No. That's not a leading question. That actually is an open-ended question. getting close. Who else said something?
You're trying to get them to, like, you have an end in mind, and you're trying to make them say that.
That's correct. My question is going to suggest the answer I want them to give me. They don't have to give me the answer I want, but my question is gonna be phrased like this. Isn't it true that you in fact murdered that man on that day, on that street, at that time? That was you, wasn't it? So I've already that's why they say lawyers liars, right? I've already said what I want the answer to be, and all I'm asking this hostile witness is to either say, yeah, you're right, or no, you're not right. I want them to agree with me. So a leading question is a question that really suggests the answer. I'm telling you what I want the answer to be. You are free, of course, to agree with me or disagree with me. But I am entitled on cross-examination to make that witness give me a straight-up yes or no to my question. Then if the witness feels he or she needs to explain their answer, then they get to do so. But I'm entitled to a straight-up yes or no. Yeah.
Is the same way granted if the witness can be shown to be a hostile witness, for instance, in the trial that, like in a criminal trial, if you were to bring, like if you were to bring someone from, who was in jail with the defendant, with the person that you're
Right.
prosecuting, obviously if you're.
They might be hostile, they might not be.
Right,
Right.
but obviously if you're the prosecutor, you know, unless they have a deal,
They're gonna be hostile.
they have no motivation. So,
Right.
at least I can say from the trial that I sat on, questions like that were permitted.
Yeah, sometimes a witness, even for your side, is in fact, as the answers start coming out, reveals herself to be a hostile witness. In a civil case, that like gives the lawyer for the plaintiff or whoever's witness it is indigestion, because you don't want to be putting up somebody, you don't want to offer as one of your witnesses for your side of the case, somebody that freaking ends up disagreeing with every question you ask, right? That doesn't look good. This is my witness who's supposed to help my client. Every answer she gives is negative, or she's evading it. So there is this little technique, you don't have to worry about this, it goes beyond what we're talking about, but since Sonny raised it, there is this little technique where you say, Your Honor, I'd like permission to treat this witness as a hostile witness. It's not a good thing when it happens, because it means, oh, hell, our witness just turned on her. This is getting good, right? From the jury's perspective. From the parties or the lawyers, it's like, yeah. So, yeah, that can happen sometimes. So, again, on direct examination, you cannot ask leading questions. The questions must be open-ended on direct examination. So, those questions are questions that do not suggest the answer. They're open-ended. What happened in the cafeteria on January 12th, 2014? Tell the jury. What did you see at lunch on that day in the cafeteria? Or I might start with, so ma'am, you were present in the cafeteria at work on that, you were present at work on January 12th, 2014, right? I was. Did you go to the cafeteria for lunch? I did. Do you remember if the bad guy, the harasser, do you remember if Mr. Smith came into the lunchroom at any time when you were in there? Yes. Was my client in there with you? Yes. Would you please tell the jury what you heard and saw Mr. Smith say and do, if anything? I'm not suggesting the answer. I'm asking a question that's going to elicit the answer or the story from the witness. That is what you do on direct exam. So I do direct exam, the other side gets up and does cross exam if I need to. If, because the other side made some points on cross examination, I may need to get back up and do what's called redirect examination. I don't get to go through the witness's entire testimony again. I just get to ask a few more questions about any problem areas that I wasn't happy with her answers on cross-examination. When that's done, we then plaintiff call your next witness, and we go through this process, direct, cross, redirect, with every witness the plaintiff has. Once the plaintiff has put up all of her witnesses, the plaintiff rests. That means we are resting our case, Judge. That Judge then says, defense, call your first witness, and we go through the same exact process again. Only this time, the defendant's lawyer is gonna be calling his side's witnesses, so they're gonna be friendly. He does direct exam. There are witnesses for the other side. I get up and do cross